do I get it scanned? You know what? Yeah. I'll just check. Are you ready?
Technical difficulty. Yeah. Yeah.
My Lords, my Lady, I was looking at the features of what I described as holding out as a unified group.
Yeah.
I'll just pick up one matter which my Lord Justice Coulson asked, which was the date of the service of the statement of claim.
Oh, yeah.
The answer to that is the 23rd of March of this year, and in fact it was in an email from the third party's solicitors, which is at bundle S, supplementary bundle tab 2, page 28,
Right.
where there's a reference to the statement of claim being served by the 23rd of March, and my instructions are that it was indeed served on the 23rd of March. And although there had been an earlier intimation, it is also, that says, I formally confirm that M of, and then the generic name has been given, has been engaged as the third party's quantum expert and is already working. The third party, we've noticed, with other experts in disciplines by 27th of July in accordance with the Tribunal's direction.
Yeah.
Incidentally, don't tell us any names if they're confidential, but are the two tribunals the same, or do they have common members, or are they entirely different?
They're different.
Okay, thank you.
They're distinguished but different.
I took it for granted that they were distinguished.
I give no warranties as to the equality of arms in relation to them. They're certainly both distinguished. In relation to then other matters which I draw attention to, can we look please at the evidence which was actually filed on behalf of X, and in particular K, which is in the supplementary bundle at tab 3.
Yeah.
And for these purposes, just identifying and picking up the documents which were sent and which you've already looked at, exhibited at tab 4, page 105.
Yeah.
K on the generic email, emails on the 18th of March 2019. Could you please send the details of the parties and the project so we may run a conflict check? I'm conscious that we are sometimes approached by both sides, so it's probably better to run that as soon as possible. Now, a number of points arise out of this. My learned friend was driven this morning to what in my submission is the logical conclusion of his position, which is that it would have been perfectly all right, subject, he says, only to maintaining information barriers, for Y at that stage to have been engaged as a delay expert for the contractor and for the answer to be given back as it was. I can confirm there are no conflicts. Could you also let me in the name of the project? Now, in my submission, that is, with respect, utterly unrealistic. It's utterly unrealistic for at least 3 reasons. First of all, it takes no account at all of the point which I'm in the course of making, which is of the generic branding of the defendants as a whole. And given that generic branding, had that occurred, cross-examination could have taken place along the lines of, well, your colleague who appears on the same website, held out by you as competent and so forth, agrees stroke disagrees with you, agrees with someone else, and you could have been cross-examined, he could have been cross-examined upon the basis of differences by reference to, as it were, different opinions. Perhaps more significantly, if the expert fundamentally disagrees with one of his colleagues, he is unlikely to give vent to the full extent of his disagreement in circumstances where he is being held out and marketed by the same organisation. In other words, actually the very thing which my learned friend says is important, namely independence and impartiality, is actually compromised by the existence of a colleague being instructed on the other side. That's
I suppose there would be scope for embarrassment too if they were at different levels of seniority within the organisation.
Absolutely, certainly, my lord. Absolutely, different levels of seniority. You were trained by him, he trained you. Have you got any reason to suppose he's not competent? All those bits and pieces of matters would be open to exploration and examination. The second type of conflict, which in my submission should be taken into account, is the conflict which arises from, on the same matter, on opposite sides, you having 2 different clients. Gives rise to, well, which is more important? Who's likely to be with us in the long term? Is this case going to settle? Will it go on? And so on and so forth. None of these are consistent with true independence. And the third matter is that in relation to ongoing and large disputes, although of course, arbitrations are confidential, you only have to look at the CVs of those, whether they have been quantity surveyors for 6 months and subsequently held themselves out as delay experts, or, in fairness to the experts in this case, those who have been considerably greater and longer CVs, to show that they say when they have been successful and when they have not been successful. In other words, there is a premium being put forward on giving advice which you stick to and which goes forward. Now, none of that in my submission is improper. It's part of the business of expert witness work. The law in this country has done an awful lot to try and avoid the getting of hired guns, but it cannot avoid the commercial reality that litigation support in the construction field by both quantum and delay experts is an enormous and big business, with teams of people running up substantial costs, inuring to the profit of organisations. Carrying on, and just to, just as it were, to follow through that, until the abandonment by my learned friend of the case in relation to breach, the response and documents show not that the defendants were saying, well, there couldn't possibly be a conflict because the Singaporean company X has had no involvement. We can't speak at all about our London or other operations. These documents are only consistent with being understood by Kay. When he says, I can confirm there are no conflicts, he is speaking for the defendants as a whole. If one then goes on in the exhibit to his document, to page 109, tab 4, page 109, which is the email which he writes on the 8th of October of last year. Dear, and this is a reference to the solicitors, hope all's well, our firm has received inquiry from lawyers representing the third party on its potential dispute against A Company on the A Company complex. They've asked for quantum delay experts outside Asia to assist them on the matter and have requested us to run a conflict check in respect to the same. We've informed them that we are currently engaged by A Company on a separate dispute on the same project without revealing any further details, and they don't seem to consider it as a conflict. We told them we'd be speaking to you regarding the same as the well. Since the third party's contract is for EP and CM works for the full complex, and our engagement is in relation to the evaluation of delays on the construction subcontract for non-process building, our view is that working on the two matters in different offices wouldn't constitute a strict legal conflict. Nothing here of, well, they could be employed by different ones, simply taking the view now abandoned that there isn't a conflict. And then our ability to set up the engagements in the manner that there is required physical electronic separation, hoping to have a chat regarding this. Would you be available anytime soon?
Mr. Hollander could respond to all of this by saying, well, this is all post facto, and how does this help us construe what the contract was or what the duties and obligations were at the time of contracting rather than post facto?
2 points, my lady. We've looked essentially at very similar pre and post contract. Yep. It is, in my submission, evidence of understanding. It's the same sort of understanding as in my submission would be the case. If, as is the case, you get White and Case, and we know this from the decision, the Georgian decision that you looked at, who unsurprisingly sets themselves up in different jurisdictions with an English LLP, no doubt a Delaware LLP, and no doubt all the other places that they look at. They have a unified conflict system. They have the ability to put information barriers. But it would be entirely unreal to suppose in those situations that if you aim to hire White & Case in London to do a piece of litigation and you did a conflict check in relation to that, the fact that in New York by a Delaware LLP or possibly even a New York LLP, whatever the corporate vehicle is, with appropriate information barriers, there would not be said to be a conflict of interest. Now,
This is certainly consistent with the case you advanced, so this correspondence, you say.
I do. I'm seeking to make a slightly different point, my lady, which is this. Solicitors, as it were, everyone accepts their fiduciaries, they owe duties, confidential legal information, duty not to act for people with opposing interests, all that. The same is true in my submission in relation to accountants who provide litigation support services. One gets that, some support from that from Bolkaya, albeit in the context of confidential information because the point had ceased, but from Lord Millett's speech in that, you get the equivalent treatment. You also, in my submission, get support from that from the decision of Mr. Justice Briggs. My submission is that looked at in that prism, this sort of expert, delay or quantum, a large team of backup support, doing initial process of advice, litigation support and so forth, be entirely unsurprising to have the same approach to them. And indeed, if you wanted to have a different approach, you would have to make that clear.
I suppose you would say that this email shows or is evidence of how they saw themselves, that is to say, one firm, two offices, and therefore is evidence at any rate of how everybody else was likely to see them.
Absolutely. Precisely so, my lord. If one then looks, as it were, a bit further than this, and looks and sees what the witness says in the body of his witness statement about the process of which was undertaken, well, just to pick up a point on page 97 of this bundle, tab 3, this is the initial email.
97.
97. It's paragraph 13 of
Oh,
the
right.
witness
So in the body of the statement.
in the body of the statement.
Yeah.
Yes.
So, yeah.
This, of course, is pre-contract. Please would you confirm by return that you're not conflicted to act as an independent expert witness in this matter? Pre-contract, what does that lead to? 14, later that day, I ran a claimant check on the claimant in this arbitration, and it gives the name, and the company which was intending to instruct me, i.e. my clients, a company. Now, just pausing there, suppose that the engagement had been the other way round, and that Mr. M had been appointed by Y in London to make a quantum claim in relation to invoices arising out of this project against my clients.
So it would have had to throw up a positive result.
That would have thrown up a positive result simply because of the existence of my client's name in relation to that. The learned friend has to say in relation to that, that would have been fine. We could have said there was no conflict in relation to that. And the reason he has to say that, of course, is because on the terms of the contract, they not only confirm there are no contract, they're going to become, they're going to remain conflict-free during the time of the retainer, and so that's the only answer which is consistent with there being no conflict. And what that therefore involves is saying this, that a client in my position, the position of my clients, could understand and expect from a company providing expert witness services that they would say there was no conflict, even though one of their managing directors had already been engaged to prepare a claim in relation to quantum against my clients arising out of the same project, where the claim being put forward was by the EPCM provider who had supervised, instructed, and so forth, the subcontractor who was the subject of the second arbitration in the hypothesis being put forward. When you then get to what Mr. Kay says as to what occurs, he sets out the email which we've already looked at, page 99. Paragraph 25, he says he spoke to one of my instructing solicitors who told him that he thought there was a conflict. And then this, following that conversation, our internal conversations focused on two matters. Well, we'll see when we see Mr. N's witness statement that that internal conversation is not internal to X. It's an internal to the defendant group. The overlap between my expert field and the other expert's field and the physical and ethical barriers in place between X and Y. And so, therefore, what is being said is that they felt free to discuss the position between the defendants as to overall conflict, and those are the reasons that they felt that they could continue to act. If one then looks at what Mr. N says, his witness statement is to be found at tab 2. Sorry.
7, isn't it?
Yep.
Sorry, tab 5. I'm talking. Sorry.
7, I think. N.
Oh, sorry. Yes. Yes. Tab 7. I'm sorry. Just on this point, bottom of 126. Note the generic first name of all defendants. Conflicts checks are run by managing directors and individual entities. Where any issues arrive, they're immediately brought to the attention of, and then an individual is identified who's the founder and CEO of the generic and myself. We then seek to understand the situation, determine how to proceed, and instruct managing directors accordingly. Now, just in relation to that, it is N who produces the conflicts of interest guidance from the RICS of the 1st of March of 2017, which is to be found at bundle 131 of the same bundle. Now, the part of the curate's egg which I fancy eating from my learned friend's book is where he says that generally professionals will owe a fiduciary duty, which I'll show you in due course. But for present purposes, the important point is that this is the professional guidance being produced by the Royal Institution of Chartered Surveyors, current at the time in relation to what is meant by conflicts of interest.
And this is the document that you referred to in your skeleton.
Yes.
I had a bit of trouble tracking that down. That's right, there wasn't a cross-reference, but this is, I've cross-referred it now. There's some stuff about when you're looking at related companies,
Yes.
common
Yes.
share.
Can I just show you the relevant
Yeah, of
bits?
course. Yeah.
It's under professional statement. And just to be clear, this is binding professional guidance on chartered surveyors regulated by the Royal Institution of Chartered Surveyors. Page 139 identifies under conflicts of interest, paragraph 1.1, an RICS member or regulated firm must not advise or represent a client where doing so would involve a conflict of interest or a significant risk of a conflict of interest, other than where all of those who are or may be affected have provided their prior informed consent informed consent may be sought only where the RICS member or regulated firm is satisfied that proceeding despite a conflict of interest is the interest of all those who are may be affected, not prohibited by law. And then definitions used in 4.2, conflict of interest, a situation in which the duty of an RICS member working independently or within a non-regulated firm or within a regulated firm or regulated firm to act in the interests of a client or other party in a professional assignment conflicts with a duty owed to another party or party in relation to the same or related professional assignment, defined as a party conflict, a situation in which the duty of an RICS member working independently, etc., or regulated firm, etc., conflicts with the interest of that same member firm, an interest conflict, and then a confidential information conflict. And then informed consent is identified. And then in relation to the commentary, if you look at 142, you see first of all at 4A, if a single regulated firm accepts 2 or more professional assignments in connection with the same transaction or related transaction, and the respective client's interests conflict, there will probably be a conflict of interest or a significant risk. Then there's discussion about multidisciplinary firms. And then over the page at 143, related firms. If 2 unrelated firms act for 2 clients in the same transaction with competing interests, neither firm will have a party conflict. However, if those 2 firms are related, an increased risk of a conflict of interest arises. The effect of the professional statement is that firms must each consider whether their own business and ownership structures give rise to inherent risk of breach of the professional statement. RICS anticipates that conflicts of interest are unlikely to arise simply by business ownership structure if the following criteria are all satisfied. The firms are separate legal entities, okay. There are no directors, partners or employees in common between the firms. Well, initially it was said by N that that was the case, but it's accepted that that was simply wrong, and that in fact the individual who is referred to as the founding partner is shown to be the sole director of X and one of 2 directors of Y. Then there is no direct or indirect fee sharing between the firms. I'll have to come back to that when we look at L's evidence. No information to confirmation or common internal data sharing arrangements relating to the area of information. Well, even on that, given the conflict sharing, one questions that position. But in relation to no direct or indirect fee sharing, you've seen the structure which is identified and was produced by the respondents, which is to be found at tab 8, page 130.
Yeah.
What you see is that sitting above the firm on the right-hand side, that's the ownership of X and Y. Z is in fact on the left-hand side. There are individual shareholders who control 40% of the overall matter. They aren't identified. The highest individual is less than 20%. And there is a common funding undertaken by JLL, sorry, the funder, which is described at the top central part of the page.
Yeah.
Now, what Mr. N says about this in relation to his evidence is at page 128 of tab 7. You should have at paragraph 17 the amended version of his witness statement when he pointed out the mistake. He confirms separate legal entities, crosses out no directors, partners or employees, and then said there is no direct or indirect fee sharing between X and Y. And then over the page he says no access to information or common internal data sharing between X and Y relating to arbitrations in this case. Well, you've got my conflicts point, but if you look at the way in which the matter is put together, the assertion that there is no direct or indirect fee sharing is, in my submission, at least open to substantial question, given that you have got the right-hand company, ending in international, sitting above the two. Now, I don't need to rest my submissions in relation to that. You've got already the common funding. If you then look at page 153 of, this is the second witness statement of my instructing solicitor. He refers to the profiles being put forward. The first expert's profile, this is on page 153, says that he's part of the company.
Sorry, where are you reading from?
I'm sorry, top of page 153, third line, my lord.
Third line, right. So this is in relation to K.
Yeah. Says that he's the managing director of the Asian operations.
That's X.
Yes. It's
not a
managing director of...
Actually, sorry, no, it's not. Yeah.
I was going to say it's a reference to, because of the reference to the operations, it's a reference to X, but actually name-wise, it's back to the point you already made.
Exactly.
The generic, I mean, that's the same name as in the generic email address.
Yeah. His profile has got a Singapore mobile number and a reference to Singapore, but nothing to suggest anything other than the part of the generic, and we've got the email. And then while Mr. M's profile doesn't mention the fact that he's part of the generic, there's the email address and there's the announcement saying he was going to expand the generic UK business. Please join us in welcoming him to the international team. And then when that creates a link, that goes to key professionals, and that identifies them as key professionals, including others like the founder and managing director, who is in fact a director of both X and Y. The evidence for that is then at 14. We've already seen that that's accepted by the change which has been made in the evidence. Now, my lords and my lady, I regret that the part of the exhibit to that which contains the financial statements has been missed out. You should have that exhibit provided. I just want to look at one page of that exhibit.
Hang on. Which page is this?
Page 67 of the exhibit GH2, which is the.
So where in the is this in the bundle? Or not?
No, it got missed out of the bundles through through inadvertence, for which I'm responsible. I'm afraid I only discovered it when I was looking at the non-alum.
I've got this. This was separately on the.
Most of this are the financial statements from which the evidence you've just been looking at looked at, and we don't need to look at those. But you should have at page 67 of the bundle numbering.
Well, you'll have to go for the internal numbering because I've just got this as a.
I think it's only internal numbering. Can we see it? It's the last page, I hope.
There's a completely different type of document.
Yes.
Yeah. It's not the financial.
It's not the financial statements, and what it is a record of the press release announcing Mr. Kay's joining, and you'll see that it says, second line, that he's going to lead the generic charge into Asia, whilst also contributing to the firm's ongoing success in the Middle East. And then from the managing director, the addition of him enhances our international presence with a world-renowned expert. Mr. Kay's reputation, experience, position, and then the international to capitalise on the growing construction sector in Asia and the Middle East. Going to be located in Hong Kong. And then about the international, the generic is recognised as a global leader in project management and dispute resolution services to both public and private sector clients. The generic team of experts has extensive experience managing construction disputes and resolving disputes of all types and sizes. Our professionals have given testimony on delay, disruption, and quantum matters in most international dispute forums, has offices, and then there are a series of offices which are identified.
Sorry, what year is this? June 18?
It's when Mr.
When he
Kay joined, which is,
don't worry.
I think no, we have got
Obviously
that
before.
somewhere.
Don't worry, it's in the evidence somewhere.
I think he joined in 2000. Sorry.
And he joined from another well-known firm of delay and quantity surveying experts who deal with delay and disruption in construction.
He did, and he
There used to be a time, and it was all done by James R. Knowles, but we seem to have moved on from those days.
I make no comment.
Yep, okay.
Now, so standing back from all of this, what do I say the picture is? The picture is, first of all, that the business is being marketed to the world as one business with a team of experts in different places, same team of offices, and so forth. Secondly, unified conflict checking, identical email addresses, substantial backup, and then when asked about conflicts, plainly consider it relevant and appropriate to look not just at the individual company position, but at the position as a whole, position of the defendants as a whole. If one then just goes back to the judgment of Mrs. Justice O'Farrell at tab 7, she deals with the matter, as my learned friend took you to, at paragraphs 54 through until 59. Her essential reasoning is, in my submission, factual basis at 56 and 57. And she says, common financial interest, defendant group is managed and marketed as one global firm, common approach to identification and management of any conflict, as explained by N in his letter dated 19th of March. Utterly unassailable in my submission in relation to factual findings. So far as the equitable position is concerned, in my submission, equity would intervene, I make no bones about it, in this situation, even absent the no conflicts term in the retainer. In my submission, the no conflicts term puts the matter completely beyond doubt. No one in the real world looking at the no conflicts would accept that it was acceptable for a delay expert from another subsidiary to appear on the other side against the backdrop I have put forward. The defendants' collective clients would be horrified if they were to announce, we have no difficulty in having our experts operate on different sides of the same dispute.
You say that would be the position even absent a contract term. For that submission, are you assuming that they have nevertheless been asked to do a conflicts check, or are you assuming that nothing at all has been said about
My Lord, I would have to assume the following in order to make my primary submission good. First, that the work being undertaken is materially the same as in the present case. In other words, it's the same sort of work, the detailed backup and so forth. Secondly, that they have been asked to, as a backdrop, to do a conflicts check, thus showing that they are interested in conflicts. And third, that the defendants have marketed themselves and put themselves forward in the same way. And Malou, can I just briefly add to that?
Sorry, and those are the three things that you say would lead to
the imposition, even in the absence of our contractual term.
Right. Although we don't need to worry too much about that because there is a contractual term.
No, we don't need to worry about it at all, and I may be setting up something which is entirely unnecessary for me to set up, and it may be that you don't need to decide that question at all.
It's difficult to. You mean when you say no contract scenario, you mean contract but without a conflict clause scenario?
Yes.
Because there's always going to be a retainer
Well,
of some
yes.
sort.
And can I make it plain? Obviously, there could be circumstances where you write out such a. In retaining us, you have to understand and accept the following.
Yeah. Because one or two of the earlier cases, you could have looked at them and thought, well, did that not give rise to a conflict? But there wasn't any question of conflict, there weren't terms and so on. So, I mean, harmony. I wondered if that could have been a conflict. But actually, in the end, I mean, it's not dealt with like that. The point didn't arise.
Well, harmony's got the following differences to it. I mean, first of all, it's a very different type of expert. You're looking at someone who's
that's
outside court, etc. Yeah. Secondly, the retainer is over by the time that the expert is approached by the other side.
Well, that's true of more than harmony.
It's true of the vast majority of the cases. One of the unusual features about this case is that there is still a continuing relationship. We haven't terminated Kay, he hasn't terminated us. The matter is still ongoing.
Yeah.
But to come back to my Lord's point, very many of these cases simply do not deal with this position, as is common ground on both sides.
Yeah.
I would, if I may, just in this context, draw your attention. You have our note on the Kay Holdings case. And I'm sorry, we hadn't found this before the weekend. I'm grateful to both my learned friend and his pupil for discovering it, but it should have been done earlier by me. But the interesting thing about this case is that the dispute before Mr. Justice Briggs wasn't about whether the experts were going to both be retained by the merged firm. It was accepted the experts were going to not be part of the merged firm. They were going to be independent. What was at issue was whether or not the backup team was going to be allowed to continue working. One sees this, the proposals at paragraph 15
Yeah, we saw that from
Yeah.
the paragraphs that Mr.
Absolutely. So
Holland
you've got the point I'm making. Sorry, I can make this more shortly. The point I'm making for present purposes is no one thought it would be okay for the experts to be both retained by the merged firm and carry on. That was never going to be acceptable. And I do submit, contrary to my learned friend's submissions, that the term, the material term, which was the amendment at the
Clause 7H amendment was very similar, you say.
7H, not undertaking any act or enter into engagement would or might put us in a position of actual or perceived conflict. In my submission, there is no material difference in relation to that. And that would have been sufficient, but for the acceptance of undertakings, for Mr. Justice Briggs to have granted an injunction against the merger of the two firms. Unsurprisingly, you may feel, undertakings were proffered in order to avoid that particular injunction. Can I just make one point about conflicts of interest, which arises from a sentence in Mullane Friend's skeleton, where they say that conflicts of interest can mean different things when you're looking at the position of someone who is deciding something, like a judge or an arbitrator, or indeed an expert who's appointed to determine a dispute. And of course, in one sense, they're right, that what you're looking at is concepts of apparent bias. In the field, however, of arbitrations and so forth, there is a wealth of material dealing with the circumstances in which you can or cannot act qua arbitrator and so forth. That does inform the duty of an expert to this extent. If he accepts an engagement on behalf of a client in circumstances where he is or is perceived to have an alternative interest, his evidence becomes less valuable in the hands of the client who is instructing him. Because one of the first things I'm afraid that you do in relation to any expert is you look through and see whether they have or have not given proper disclosure of their alternative arrangements and so forth. And that is, especially in the sort of disputes that we are talking about, an inevitable consequence of the fact that there are numerous decisions, including at least two I can think of from members of this court, which are very critical of experts who have not given proper disclosure in relation to possible alternative influences and so forth. The point I'm making is that conflicts of interest is given colour by the context in which it appears. It could be, for example, an own interest conflict. I mean, if, for example, these defendants were also in the business of litigation funding and they were funding the opponent to litigation, everyone would take the view that that is a matter which the client should have drawn to their attention. Similarly, if one of their colleagues, branding themselves under the same name, is acting for a party with a different interest, in my submission that falls within the relevant rubric. I want now, if I may, just to look at a couple of the authorities. I'm not going to do my learned friend the disservice of referring to him as though he were dead, because I am all too well aware that he is very much alive and will no doubt be able to bite in the course of his reply. But I do want to draw your attention to the parts of his work which I respectfully adopt, whilst also respectfully identifying those parts with which I disagree. First of all, at page A941, tab 27, volume 3 of the authorities,
Yeah.
one sees him and Mr. Salcedo discussing the term conflict of interest. And after saying that it would be more precise to use the expression conflict of duty, second paragraph, first type of conflict is an existing client conflict. The professional who acts for two clients at the same time will normally owe fiduciary duties to both. Now, the point I make is this. Belenford is, of course, absolutely correct to say that there are settled categories of fiduciary relationships: trustee, beneficiary, agent, principal, and so forth. Director to company. Solicitor and client. But in my submission, to limit it at solicitor is too narrow. And he is correct to say the professional who acts for two clients at the same time will normally owe fiduciary duties to both. Then he says the precise scope and extent of the fiduciary duty may depend upon the terms of the retainer. I'd say may well, but there we are, I agree with that. The most notable feature of fiduciary duty is an obligation of loyalty. Where the professional is asked to act at the same time for two clients whose interests conflict in relation to the subject matter of the retainer, the fiduciary obligations of loyalty to owed to each will clash, and there is an existing client conflict. If he accepts instructions for both, he'll then be in breach of fiduciary duty to one or both clients and unable to carry out his obligation to both. The conflict is a conflict of the firm, partnership, or company, not merely the individual partner. For this reason, the conflict extends beyond the individuals within the firm who act for the client to the firm itself. Follows to accept instructions for a second client, whereas a conflict of interest gives rise to an automatic breach of fiduciary duty unless both clients have consented. And even when both clients consented, there will be circumstances in which the professional cannot act because he'd be professionally embarrassed for doing so. And he then distinguishes that situation from the continuing retainer. Now, for present purposes, all I need to do really is to point to the RICS and say that certainly surveyors are holding themselves out as being professionals in the context being put forward. And I would certainly submit that, as I say, the defendant's clients would be horrified by the idea that they thought it was proper to act on different sides in litigation. The passage with which I also agree is at A944, where he identifies that the professional will owe two sets of duties to his client, one on contract, and the other set is fiduciary duties. And he discusses the context of that. 2003, page A945, after citing from Lord Justice Millett in Bristol and West against Mothew, there's a sentence about a third of the way up the paragraph. The relationship of fiduciary is present both where the professional acts for the clients in the performance of a task, which involves a measure of delegation to the professional, and also where the professional is instructed merely to advise the client as to a proposed course of action. Here the relationship of confidence, the dependence upon information and advice gives rise to the same type of obligation. We're just exploring that a little in this case. You hire a delay expert you're looking, as we can see from the terms of the retainer, in this case, to that delay expert going through the papers and information, identifying the critical path, and then identifying causative aspects to it, helping you in relation to disclosure. It is obvious from the advice that is being given that that is of importance to the strategy which is being involved in a substantial piece of litigation. Now, of course it is the case, that when he comes to give evidence, his essential duty is the tribunal. And if it turns out that he's got something wrong, new facts turn up, etc., his obligation is to say so immediately. We know that that does not mean that he is immune from being sued by his clients. That's the decision by the majority of the Supreme Court in Jones and Caney. In other words, despite the fact that he may have to admit that he's got it wrong, he still owes the duty, but he can be sued by his clients in relation to the advice that has been given earlier on. In my submission, there is nothing in that which precludes the existence of a fiduciary duty. Of course, the fiduciary duty cannot mean that he's absolved from his duty to the court, or indeed that it's anything other than the primary duty. But it doesn't allow him suddenly to say that his partner or his assistant company, or wherever it is, can appear on the other side of the litigation. Then one sees the discussion vulnerability. I do not represent a widow or an orphan.
Sorry, where are we looking? Vulnerability?
Vulnerability, my lord, it's in the middle of page A945, after a reference to an article in the Law Quarterly Review by Lord Millett.
Oh, yes, sorry. Yeah, got that.
My client is a very substantial corporation. We'll say it must be to have been paid the bills, then this particular matter.
It wasn't before, it is now, you mean?
However, that doesn't mean to say that it can't be vulnerable in this sense. Once it's embarked upon the course of litigation, depending upon solicitor's advice, or I would say, the advice which one sees in of the sort being put forward by the defendants, it is in a vulnerable position. Changing horses, swapping over, operating in a different manner is difficult. And the protection which I say equity gives, alternatively contract gives, is limited, frankly, to making sure that its interests are focused on doing as good a job for me as it is possible to do without any abrogations or limits on that loyalty. And my lord, Mr. Holder explains perfectly correctly at the top of A948 that the rule which prohibits a fiduciary from acting for two principals with potentially conflicting interests is prophylactic. Prophylactic because it prevents the fiduciary from being in a position where a conflict of two inconsistent duties arises. Now, it's against that backdrop that we come to the part of the egg with which I respectfully disagree, and that starts at A950, where he discusses the position of experts. And he criticises the decision of Mrs. Justice O'Farrell at A953, paragraph 5015 and following. She says, he says, 103, the only basis of the finding of fiduciary duty was a single sentence. This is the bottom of the top paragraph on 103, so A954, to the effect that the expert was engaged to provide extensive advice and support for the claimant throughout the arbitration process. In my submission, that's not an entirely fair characterisation of her judgment. The decision is expressed in the widest of terms. Although the anonymisation makes it difficult to understand the relationship between various defendants, the two experts appear to have been employed by different legal entities in the same group. They are instructed as experts as individuals, or one can see with respect that that's wrong. The instruction is of the companies, albeit no doubt having access to the resources of their employer as a support. Well, one can see how extensive that support was in the case of my clients by reference to the invoices totaling $635,000 until January of this year. A fiduciary duty of loyalty is inconsistent with the obligations of the expert to the court. I respectfully disagree with that. It is not inconsistent in much the same way as the existence of the duty is not inconsistent with the contractual duty. And no case has ever previously reached such a conclusion, and then no basis for imposing the same duty on other persons merely because they're members of the same corporate group. With respect, that's not fair either. The position here is that the corporate group had held itself out as being a single group in all of its communications, as we've previously seen. With that introduction...
Hold on. That's what Mr. Honda said in his book about the case. Obviously, that's prior to his instruction. I completely understand that, but I've just spotted, and I hadn't spotted it before, and it's my fault. This bit comes from a completely different section of the book.
Yes.
It's not my fault. I had simply read the heading fiduciary problems before, during and after the retainer, which is the main heading before expert, but actually I noticed that in the book we go from 31 to 99. So this is concerned with, this section of the book is it headed appearance of impropriety, and that must be under, I assume,
yes,
it's a section dealing with
it's gone from section 2, chapter 2 to chapter 5.
Yes. I wonder if you allow me, Mr. Honda, could you tell me what chapter 5 is headed?
It's called Profits Made Out of Fiduciary Position. You get that from A927 model.
Chapter 5 is headed Perception of Impropriety as a Test for Conflicts.
Say again. Perception
of Impropriety as a Test for Conflicts. And that chapter looks at the various situations where perception of impropriety is used as a test or considers circumstances. I'll make available to the whole chapter.
I don't know whether it's on my shelf.
I'm sure it is, but just in case you lost it.
It's under his pillow.
Absolutely. No, sorry, that was my fault. Forgive the interruption. It was just that I had only just spotted that we went from one section to another, and that now makes much more sense. All right, thank you very much.
And I'm sorry, I've also just given an inaccurate answer, having looked at the wrong bit of the index, for which I apologise.
Right, so that's the bit of the curate's egg that you don't regard as excellent.
That's the bit of the curate's egg which I do not regard as being excellent. Can I just look at one thing just to see if I need to go there? I don't think I do. Yes, can I very briefly just deal with one short point on potential conflict? One of the points that is made in relation to the case, and I'm not sure if it's really there now given the breach point is gone. One of the points which is certainly made is, well, we don't think there's an actual conflict or a strict legal conflict. Once one is into the language of conflict, the bar for deciding that there is a conflict is really quite low. Of course, it's the case that in this country there is no bar to operating in entirely unrelated transactions. But in the field of arbitration, where you have got, of necessity, the engagement of an expert at an early stage, an investigation taking place, looking what the facts are, it does not take much to say that if you accept an engagement on behalf of party A, where parties B and C are also involved, you are doing so at your peril. Because we all know that until you've worked out what your case is, who was responsible for what delay and so forth, where a case will go is very difficult to go. Now, there are really quite a lot of authorities in relation to the principle about potential conflict, but can I just go to Snell in this context at tab 26, A937. This is a discussion of A936 of conflicts between duty and duty if a fiduciary acts for two principals to whom he owes conflicting duties without the informed consent of both, acts in breach of fiduciary duty. And then over the page, potential conflict, it is an automatic breach of fiduciary duty for a fiduciary to act for two principals with potentially conflicting interests without the informed consent of both. And cited in support of that is, amongst others, Bristol and West and Mothugh, which we got in the bundle. It's unnecessary for the two principals' interests and the duties which the fiduciary therefore owes to each actually to be in conflict. The double employment is sufficient to constitute a breach of fiduciary duty if the fiduciary puts himself in a position where his duty to one principal may conflict with the duty to the other. My Lord, there are a vast number of authorities which have been cited to you. In our submission, most of them, I regret to say, are of comparatively little assistance for the following reasons. One, they deal with confidential information where there is no existing retainer. That is not our case, and it is absolutely fundamental that there is a distinction between an existing retainer and a lapsed retainer. As Lord Millett makes plain in the Prince Geoffrey case, confidential information obligations go on after the end of the retainer, but absent some special term, the obligation of loyalty comes to an end with the retainer, and we are in the present rather unusual situation where we are still retaining X and we are still retaining K in an ongoing position, and where but for the injunction the third party would be retaining M and his team going forward. Secondly, none of the cases really deal with or grapple with the position of the sort of experts that we have here. I accept, of course, that they are different from solicitors. My submission is that they are most similar to accountants who are providing extensive litigation support activities, although I accept that you can always draw factual differences. They are a very long way indeed away from the sort of limited experts, an example of whom would be the document examiner in Lord Denning's case, the Harmony Shipping case. The next point is, I of course accept that one has to start with the contract, see where one goes in relation to it, and then see what the obligation is. That's apparent from several of the authorities, with the exception of the Mr. Justice Briggs decision, IK Holdings. I do say that none of the cases really have an express no conflict rule. It was sought to be alleged on very different facts in the Australian Federal Court in the Wimmera case that you could imply such a duty. The court rejected such an implication on the facts of that case, not least because it was quite apparent that there was a practice of providing expert evidence for a number of different parties.
But Wimmera is the patent case.
Yes.
Where the involvement of the expert first time round wasn't Carr expert, but was involved in the registration of the patent.
That's right. If you look
so
at...
that's not an existing retainer case.
No, it's not. It's not. But if you look at...
Are there any... I mean, I know that there are very few cases, Wimmera and Sweeney, which deal with the fiduciary duty element, and I know what you both say about those. Are there any cases with two existing retainers, effectively two parties arguing about whether both are entitled to the export or only the first in time?
The closest, albeit not exact, is the Mr. Justice Briggs decision.
The Akai.
Because, of course, what you've got there is a position where, upon merger, albeit with the point that I've already made that it was always accepted the experts would, as it were, be hived off, the position of the merged firm, ideally, was that it would act for both with information barriers or for neither.
Yeah. Sorry, I interrupted. I was just... I mean, you've both been very frank that the cases are of, for both of you, limited assistance, and I'm just because speaking for myself, I think the question of existing retainers is an important difference.
In my submission, it's extremely important. It's extremely important. And of course, well, it probably doesn't matter, but in this case, what happened was that there was the existing retainer, there was the existing contract, there was then the approach in October of 2019. There was my solicitors saying they considered there was a conflict. Nothing then happened. And then there was the discovery of the engagement in the other arbitration. So the facts were...
Well, yes, I mean, I think to be fair to the defendants, the position was that, as is set out in the evidence, that the respondents, as you now are, the respondent solicitors said they thought there was a conflict, and the defendant said they didn't think there was a conflict, so the matter was unresolved. And it appears that against that background, why did the work that
Yes.
then found itself attached to the particulars of claim in arbitration 2?
That's right. That's absolutely
Depending, it obviously depends on the outcome of this appeal, but that work was done, therefore, you would say that work was done at risk.
Yes, I would say we'd made our position plain in relation to that.
Yeah.
It probably doesn't matter for present purposes, but
No, but it's a relevant, consideration. All right. Anyway, sorry, I interrupted. So you say the closest on the facts in that way, at any rate, is Akai.
yes. I think
Yeah.
I will. And the other observation that I would make is this. I do accept that delay and quantum experts are not solicitors, they're not lawyers, and so forth. When you, however, look at the position of experts, there is, in this context, some help to be obtained from the speeches in Jones and Caney, fundamentally because of the rejection. Sorry, just to remind you, and I'm sure you've all got this, as it were, well on board. The state of the law at the time of Jones and Caney was that, pursuant to a decision of Simon Tuckey, it was understood that expert witnesses were exempt in relation to the work that they had done for clients. And that was a decision called Palmer and Durnford and Stanton and Callahan. And those were the decisions which were overruled. Against that, you'd obviously got the background of counsel's immunity from suit, Saif Ali, and so forth. And so in that context, the court had to consider the relationship between what experts do and what advocates do. And what Lord Phillips identifies is that after he's seen that in Hall and Simons, which got rid of barristers' immunity, the House of Lords had, as it were, their reasoning, in particular that of Lord Hoffman, was consistent with keeping immunity for expert evidence. He considered the extent to which there is a valid distinction between advocates and expert witnesses, and one sees that at paragraph 37 at A239. And just above that, I won't read it out, but you'll see that Lord Hoffman in particular had accepted some 9 years before the continued immunity of experts. And then he returned to the question as to whether expert witnesses can be compared to advocates at paragraph 46 on A241. And one sees him referring to a decision of the late Mr. Justice Laddie in paragraph 48.
I mean, this is the heart of your response to the main point pursued by Mr. Well, I say the main point, but you can see it from the narrative in his book as to the critique of the judgment below, which is that it's said to be the CPR and everything have changed the landscape. and an expert can't possibly owe a fiduciary duty because of his overriding duty to the court. And you say that is answered head on.
Absolutely.
Paragraph 49 and 50 of Jones and Caney.
Absolutely, my lady.
That's the thesis behind the distinction relied upon in relation to experts is the duty to the court, and that's what's addressed here.
Absolutely, my lady. Absolutely. I was going to refer to the article, which is an entertaining article, the expert witness partisan with a conscience in paragraph 48, which Mr. Justice Laddie, with characteristic humour, referred to in that judgment. But I won't take up time with it. Your ladyship is absolutely right.
Virtuous youth in the Mikado, can't resist that.
No longer enough for the expert like the virtuous youth to tell the truth whenever he finds it pays. Shades of moral and other constraints begin to close up on him. And then the reference to Mr. Justice Laddie being rightfully critical of the approach of this expert, no longer any scope, if indeed there was, for contrasting the duty owed by an expert to his client with a different duty to the talk, which replaces the former once the witness goes into the court. And then 50, expert witness has this in common with the advocate: each undertakes a duty to provide service to the client. In each case, those services include a paramount duty to the court and the public, which may require the advocate or the witness to act in a way which doesn't advance the client's case. The advocate must disclose to the court authorities that are unfavourable. The expert must give his evidence honestly, even if this involves concessions to the contrary to his client's interest. The expert witness has far more in common with the advocate than he does with the witness of fact. Now, my lords, my lady, in summary, what I therefore say about this case is that when you look at the facts which underlay her ladyship's decision, when you look in particular at the role which the experts were playing, and you look at how the defendants were structured, there was an entirely proper basis for her decision. That decision was correctly made in my submission on the basis of a fiduciary duty of loyalty. There would have been a perfectly proper alternative basis as set out in the respondent's notice, namely against the factual background, the undertaking as to no conflict was in fact given on behalf of the defendant group in this case as a whole. I don't propose, unless invited to do so, to take you through our skeleton argument identifying the role of Mr. M. I simply say the criteria in Ladd and Marshall are satisfied. Important evidence. Couldn't have obtained it before the hearing. And in those circumstances, I respectfully invite you to dismiss this appeal.
Steve.
Yes, I'm not sure which of you put this in, but can you just tell us, if it was you, what the ICC document at tab 31 of the authorities is? Is it some kind of guidance document which the ICC put out, or does it have some additional status to that?
It is a guidance document which is put out for the ICC. It's published in 2009. The relevance, so far as... Sorry, do you want to...
No, okay.
It's a guidance document. It identifies various different matters which are being put forward, and it identifies, for example, various different roles in which experts can act. The only obvious relevance is that both of the arbitrations in this case were being conducted under ICC rules.
But it's general guidance rather than, as it were, the subject of a direction from the arbitrators that this document applies to the expert's duties in the case before.
Quite so.
Okay, thank you very much. That's all.
Somebody's sidelined A1002, and I, at the moment, am struggling to find or understand the relevance of that passage. That may again be my fault.
if that was us, I would rely on it in support of the proposition that if fewer than all parties retain you, those parties will likely to want to make sure at minimum you don't have a conflict of interest with any opposing party. That might be a...
Well, that happened, so we can move on, can't we? Because there was indeed that event took place.
I hadn't placed it at the forefront of my submission.
No, we understand that.
No, thank you very much.
All right, thank you very much, Mr. Stewart. Mr. Hollander.
Well, as the appeal has gone on, in a sense, the ramifications of what is being put to you are becoming broader and broader. And in my submission, one has to go back to the starting point, which is consideration of what is a conflict of interest. Conflict, I think I've suggested that actually it would normally be referred to as a conflict of duty, but actually, because it covers own interest conflicts, where there's a conflict between your duty and your personal interest, that's why I assume the expression is used conflict of interest. So it arises when a person or a company is asked to perform duties and they are disabled or conflicted from doing that in some way as a result of some other interest or duty which they have. Now, one then says, well, in the present case, how does that possibly arise? On the one hand, you have arbitration 1, where you have expert 1 from one company, and then arbitration 2, you have expert 2 from a different legal entity and company. It is accepted that there is no confidential information issue, and therefore, in my submission, there is and can be no problem of any sort which could be described as a conflict of interest. Now, what I think the learned friend's case is veering towards, and in a sense this has arisen from the comment by Lord Justice Coulson about the chapter heading, is that actually, in a sense, his case is moving away from what is a conflict of interest to something which is much closer to an appearance of bias or impropriety or something like that, which, as your lordships well know, is the test for a decision maker such as a judge, where on judicial conflict there is a different test. But one asks then rhetorically, how can there possibly be anything which can be described as a conflict of interest in the present case, because there is no conflict of duty or interest. The learned friend posits the example where in cross-examination one says to an expert, but your colleague says the opposite. Well, the answer to that is that, I mean, leaving aside the fact it's a different arbitration, the arbitrations will be confidential, but leaving aside that point, the simple answer is I am an expert. I have no idea what my colleague is saying, and I have no information because I have not had any information as to what he is doing, in what circumstances, and I know nothing about that. And again, the sort of points that he was suggesting, well, what about if one was subordinate to the other? Well, I mean, again, that is not a conflict of any sort. It's closer to the appearance or in some way. People always, particularly in a small field, have worked for, against, under, above each other as experts, and that doesn't in any sense make it difficult for them to be experts. So at the heart of my response to what he says is really to invite the court to consider how there could possibly be said to be something which can properly be described as a conflict. One has to be able to identify what duty or what interest conflicts, or what it is that cannot be performed to the best of the expert's abilities, or that they have shared confidential and privileged information relevant to the case, which is the case that was abandoned by my learned friend below. So that's the starting point as to why we say the principal cannot be engaged here, whether as a matter of contract or equity or otherwise. It's perhaps helpful just to look at a passage, Mr. Kernaglin's book on fiduciary loyalty, which there's a short passage, I think it was in our leave skeleton, which you can find, just a convenient place to find it, which is 442, 428. Again, 428, which is our leave skeleton. When this is the passage, I will actually make available to you the original when I give you the
Your leave skeleton, so that's...
Mr. Canad, do you have 428, paragraph 42?
Yeah.
Mr. Kernaglan is an academic who has written a brilliant book called Fiduciary Loyalty. The key element that separates fiduciary duties from other duties not peculiar to fiduciaries is that fiduciary duties provide this enhanced likelihood of faithful adherence to duty by protecting the fiduciary from influences that are likely to interfere with proper performance of the fiduciary's non-fiduciary duties. The presence of such influences carries with it a risk that the fiduciary may be tempted not to perform properly his non-fiduciary duties. Removing the influences therefore increases the likelihood of a fiduciary performing his non-fiduciary duties faithfully. Thus the concept of fiduciary loyalty encapsulates a subsidiary and prophylactic form of protection for non-fiduciary duties, which is designed to enhance the chance that those non-fiduciary duties will be properly performed. And one can give an example. So my learned friend talked about actual and potential conflicts. An actual conflict is when, if I am acting for two clients, on behalf of one client, I want to ask a question in cross-examination. And on behalf of the other client, I want not to ask the same question. That is an actual conflict, and no consent is going to redeem that problem, because I cannot do my duty for both clients to the best of my ability, as it were. Potential emphasises on the prophylactic element. So the classic case is the 19th century case called Aberdeen and Blakey. Aberdeen and Blakey was a case where the director of a company who was buying chairs was also the principal of a company that wanted to sell the chairs. And what the court held was that it wasn't relevant to that question whether actually the prospective the seller of the chairs was offering the best price. Leading evidence as to whether the price was the best was neither here nor there, because the person in question was irredeemably conflicted. He had a potential conflict, which meant he could not make an objective decision. And therefore he was in breach of fiduciary duty, whether or not the price for the chairs was the best price available. That's the prophylactic element. That's the classic 19th century case on potential conflicts. So I mean, that's what's being talked about. But then one says, well, that's all very well, but what has that got to do, one asks, with the present? There is no such conflict here. There is no conflict of interest and duty that could possibly be put against X, Y, Z, or anybody else in the group. And there is no difficulty in each of them performing their obligations, whether they are obligations as expert or obligations in relation to the ancillary services. There cannot be, in this case, any form of conflict in my submission. So we are...
Sorry, but what if in arbitration one it's in the claimant's interest to accept a delay and a cost as a result of a late drawing, and in arbitration two it's against the claimant company's interest to argue that?
But the person in question has no conflict. Because
Well, this is
neither
the
he
separation.
nor-
This
no,
rests on the separation point.
does,
I see.
exactly.
Okay, but
I'm sorry, you're quite...
no, I know. It's my fault. I'm just testing it. So that line rests on the separation argument.
that is, yes.
Thank you.
I'm sorry, I should have made that
No,
clear.
it's my fault.
There is a further. I mean, the reason why this has ramifications is that the issue does not only arise in this sort of whatever view the court takes of the obligations of the expert in this sort of case. It applies in every form of professional case. So far as I'm aware, there has never been a case in this jurisdiction of any profession where it has been, where the court has said, well, maybe there is a different company in your group, but nevertheless, we will, one way or the other, whether contractual or otherwise, aggregate those for conflict purposes in the absence, at least, of an express contractual provision which requires that. And so, I mean, solicitors...
Doesn't that all turn on the facts at the end of the day?
It's never happened.
No, I understand
And
that.
I understand.
It's not been reported.
There's nothing wrong in principle with saying you have no conflict. You have then an express reference to a company in the same group. There would be no difficulty in principle in fashioning a clause which makes that expressly clear, and therefore, as a matter of contract, widens it. But what I think is being posited by my learned friend is, in the absence of any provision which has that express effect or anything remotely similar, nevertheless, he says it has that effect. And one thinks of the position of solicitors. The first thing one does, and I mean, it's possible that if your lordships come to a different view, it will all have to change. But the first thing one does in a conflict question, when considering whether a firm of solicitors have a conflict with some entity, with the same firm abroad, is to say, are they simply firms and therefore the same legal entity, or are they different legal entities? Now, it's never as simple as that, because particularly in the States, the rules are different and much wider.
And regulatory rules.
Regulatory rules are often
Change from
different.
jurisdiction to jurisdiction massively.
It's North America where, in fact, it's different, and therefore often, whatever the legal position, the firms will not do it, will not act. But there is certainly no case in this jurisdiction, so far as I'm aware, in respect of any professional, where the court has, what I say, pierced the corporate veil, but perhaps put it in less pejorative terms, and say where the court has said the duties you owe are not merely duties in relation to your individual legal entity, but also all the other legal entities in the group, or at least those carrying out similar services. And it has this ramification because, as your ladyship is right to say, that there may be factual cases where the position is different, but I think it's a standard term of solicitors, many solicitors' retainers, that they have a bland no conflict provision, which is possibly stronger, certainly not weaker, than the no conflict provision which is relied upon here. So I don't want the court to be to any misunderstanding. I mean, if things have to change, they have to change. But the effect of a decision in relying upon a non-specific clause in the way that my learned friend has put it is that certainly practices and advice in respect of a whole bunch of professionals will have to change. So I just want to make that clear.
Well, I mean, well, obviously, as my lady says, a lot of these things turn on the facts, and certainly I think we're all aware that sometimes you can get carried away with the cases you're doing a judgment in and think it's terribly important, but you know, within a year you've forgotten it, and so has everybody else. Certainly, speaking for myself, I don't think this is one of those cases.
Well, it's a matter for your lordship, obviously.
If we can remember what letters to recall this case, then it might even make our memoirs.
Which will never sell as many copies as your books.
Yes. I'm going to come back to the construction of the contract. Can I just pick up a few other points before I do so? Fresh evidence, the fresh evidence application. I don't think I need to spend much time on it because I don't think on any view this is going to make a material difference to the decision of the court in the case, which in itself you may think is an answer on Ladd and Marshall. The only issue is the letter at, the Hogan Lovells letter at the page 20 of the second supplemental bundle. It is said that it goes, but maybe we should just turn it up briefly. Page 20 of the second supplemental bundle.
Yeah.
It is said that this, so this is August of this year, 5 months after the injunction, that it goes to what the quantum expert was doing in arbitration 2, and it is said that he was drafting the quantum appendices. This is a letter which is responding to a letter we don't have, but what the context seems to be that, and it's not something we can put evidence in, or because anything that is put in by us would be a breach of confidentiality and privilege in that arbitration, and in any event there's an injunction. But leaving that aside, it seems to be so the response to a request for documentation, and the solicitors are saying they're unable to, having not been able to talk to the injuncted expert in the second arbitration, they aren't able to identify exactly what he looked at and what he did. And while they say the practical reality is that they didn't actually prepare the appendices, they were prepared by the expert and his team, and they didn't keep a record of precisely what documents they looked at, and then they complain about the injunction. I think all it's doing is effectively responding to a request for documentation and saying that in the light of the injunction, we aren't absolutely sure exactly which documents the expert looked at in relation to his work in providing, in dealing the appendices that have been served. One can't imagine that that particular firm of solicitors simply put them in without reviewing them. But that's all that the document appears to say. In fact, the information already before the court, you may have seen this already from the our short skeleton on this point. If you look at the supplemental bundle, page 23, the information already before this court, the last paragraph of the letter on page 23. This is the same solicitors that wrote the letter had explained what they thought the expert, the evidence that was required in that arbitration was. The last paragraph on the page, and the other material that's already in the bundle is on this is 163, where Milan and Friends solicitors.
Sorry, 163 of?
Same bundle.
The second supplementary bundle? No.
No, it's still a supplemental bundle. It's a letter that starts at page, sorry, it's not from the, sorry, it's 161 it starts. They're all from the same firm of solicitors, to right. Milan and Friends.
Yeah.
Case.
Yeah.
And this is explaining, this is just after the ex parte application.
Yes.
And it's four. It just explains what was done in terms of engagement of the expert.
Yeah.
And then it really shows at 4.4 and 4.5 what they did in terms of the service of the pleading, which
Yeah.
included the quantum appendices, which obviously the expert was very closely involved in the drafting of. And that's all it is. In my submission, it really doesn't take the point any further. That's the fresh. It can't possibly fulfil Ladd and Marshall criteria. But so that's all I wanted to say about that particular point. The learned friend, the Akai case, I referred to it. In my submission, that really, when one looks at it, I don't need to go back to it. The only point in it, really, ultimately, was after the various undertakings, refusal to undertake and the like, quite complicated, was whether the only argument was whether the construction of that particular clause arguably only covered arguably covered both own interest conflicts as well as client conflicts. That's really all the case is authority for in my submission, at least apart from the material about the discretion on an injunction. And it doesn't really go beyond that. That was the single argument. Just the RICS point, just very briefly, which is 143 of the supplemental bundle.
Yeah.
I'm not sure. I just want to flag up that the passage that the learned friend read from 143 is part 3, which is commentary notes. You can see from the top of 142, which are advisory in nature.
Yeah.
Give practical
Your
guidance.
client advanced this as being potentially helpful.
Yes. All I'm saying is that a friend ought to rely upon it, and all I'm saying is that it is guidance, and it's not actually even the passage that the friend referred to at F on page 143 it asks people to consider various things. That's all it goes to. So all I'm suggesting is that actually in the matters that this court now has to consider, I would suggest that doesn't take the matter any further either. So one gets, in a sense, the Jones and Caney point, and the court has the passage from Lord Phillips and the context. And there are various comparisons between expert and advocate, although we know there are differences as well, as I mentioned in opening. But there is not a suggestion that the expert owes a duty of loyalty. In my submission, that's not what is said at all. And you have my submissions as to why, although certainly certain services are provided which go beyond the expert giving evidence, they are not such as would give rise to a fiduciary obligation for the reasons I've said in opening. So I think the only other matter that I want to go back to is the construction of the contract. And we go back, if we may, to the core bundle. Now, so the contract is contained, as we know, at 139 and 146. Nobody has suggested that it was varied, and therefore whatever decision this court comes to, the court has to derive it from those two documents. And then a friend referred to so one then says, well, what is admissible as background to that? Then a friend referred to the confidentiality agreement at 143. Insofar as this takes the matter further at all, it is interesting that it draws a distinction. The confidentiality agreement, 143, is entered into between the firm on one side and the first defendants X on the other side, identified by their, as that particular company. And the confidentiality obligation is on the recipient, which is X. If you then look at the contrast, because under paragraph 3, the contrast is between, on the one hand, the recipient is an individual company, and on the other hand, is a is an entity which is defined in the next paragraph, which means more than one entity, affiliates, entities, and that expression means any of them. So one can actually draw a distinction here between the way that one side is identified in this agreement and the way the other side is. And then in paragraph 4, the recipient, which still is the individual company, without, under no circumstances, without the prior approval of the other, acknowledge to any third party. Now, any third party must be anyone who is not the recipient. In other words, that would include others in group. What is or not, and then it goes on to deal with the confidentiality obligations. So the agreement that was entered into prior was an agreement in relation to the individual company, whereas on the other side was what might be described as a group, expressly defined as such. I don't think there's anything on 144 which takes the matter any further in relation to that. Somewhat curiously, that particular agreement is subject to exclusive jurisdiction of the Abu Dhabi global market, under clause 8, but that doesn't really matter. So the only other matter that is part of the matrix in my submission, before one gets to the agreement itself, is the document in the supplemental bundle that we looked at, which is 104. Tab 4. We saw, and a friend showed you 105, which is what leads, sorry, the previous. And then we see that what is provided for the purpose of clearing conflicts, and the one-line confirmation in 104. Now, that is all, in my submission, the admissible background material for construction of the agreement itself. And it is against that the provision at the bottom of 140 has to be construed. The confirmation is in very simple and bland terms, because that was effectively what was requested. Now, what my learned friend has to do in relation to this is to say that you can construe this as not simply you in relation to the identified company at the top of 139, which is the same identified company that signed the confidentiality agreement and which is the subject of the subsequent of the 26th of May, but that means no conflict of interest in respect of all those companies in the group, to put the point my Lord Justice Mayall's put to me, who carry on similar services, notwithstanding the fact that on any definition of conflict, for the reasons I have given, that there would not be a conflict at all. And again, this is where my learned friend's submissions, I would suggest, veered away from conflict in terms of perception, or in very much subjective perception. And I would respectfully submit that there is simply no material on which the court could reach the conclusion that that sentence and the, if you like, the warranty which comes in the second sentence can be construed against that background to mean something which could easily have been expressed if it was. I mean, we can see who has drafted this by the name on the top right of 139. That actually this can be construed so that it means you have confirmed that you have no conflict of interest, and none of the companies in your group have what would be, if it was you that had done it, was a conflict of interest, or some other express wording which covered the position. This is actually, we would suggest, seeking to build a mountain out of a very bland and innocuous clause, in the sense that I would suggest is intended to not to do anything that is, I mean, I've made the point already, that is unexpected. And that is the mountain that we would suggest that Malone and Friend has to build his case on to be able to get over the problem. And if one asks the question, do you have a conflict of interest because a different company in the group with whom you have no connection, or with whom the claimant A has no connection, is involved in a separate arbitration on the same project? But that simply isn't a conflict of interest by any stretch of analysis. So unless, I think unless there's anything further that I can assist the court with, I think those are my submissions.
You corrected yourself after you referred to J, but is the identity of J really confidential, given front page of the unredacted, of the redacted judgment?
Got to work out who J is. I think that's a matter for Malone and Friend.
Well, probably is, yes.
I don't think that my clients feel very strongly about J being confidential.
No, well, I raised it because of the way that Mr. Hollander corrected himself, but thank you.
I was just annoyed myself because I'd only had one slip in the entire day, and that seemed to be a second one.
I mean, we have to be frank and acknowledge that, you know, in 6 months' time, when people are lecturing on this case and our judgments, it will make it plain who counsel was and who their instructing solicitors were, because it does on the unredacted version, sorry, the redacted, even on the private version, which is all we will be producing, having had you both having kept so scrupulously to the rules, we shall simply do one version of our judgments, which is referring to the anonymised parties. Yes.
Sorry, Donald, I was just going to make one thing. Malone and Friend said about decisions in relation to conflicts and so forth. There is one decision which I am aware of, which is the follow-up to the White and Case decision. It may not take it very much further, but in that case, there was in fact a conviction by the SRA of White and Case for them acting in a position of conflict, where the New York office and the London office had acted separately.
Well, I was involved in that, and certainly, I mean, there's the facts. There's some facts set out in the agreed facts in the decision, but certainly that I don't think no court has reached a decision. I really that was never an issue in that case. There were all sorts of issues. The issues in the SDT proceedings were in fact quite different from the issues before Mr. Justice Field. I wasn't involved at that stage, and Malone Friend isn't right in respect of that. There was no point taken for a whole variety of reasons in terms of separate company, because there was an enormous, because essentially in the two matters, the different White and Case entities without effective information barriers were acting, and it just didn't arise.
Lord, all I was going to say about that was, in the light of what Malone and Friend says, if your lordships would find it helpful to have that decision, we can provide it. But that was the only point I was going to make. Malone and Friend did make a series of submissions which might be referred to as floodgates, etc. arguments, but there we are.
Well, I'm not sure. I don't think we're at the moment. I don't think we're concerned about that. I think we've probably got enough authorities. So I say this, and this perhaps is for your learned juniors. Could they just check, please? I'm 99% sure that it is irrelevant, but there was a case 3-4 years ago in the TCC where it's not very good, is it? Either Mr. Justice Fraser or Mrs. Justice Jefford, I can't remember which, produced a judgment which was very critical, I think, of an arbitrator who was dealing with 2 delay arbitrations, one a subcontract dispute, one a main contract dispute, where there were completely different points being alleged. I think it was an arbitrator, not an expert. If that's right, then the case is irrelevant for the reasons that we've just been looking at. But could they just set my mind at rest that that was an arbitrator and not an expert? As I say, I'm 99% sure it was, and I'm sorry I can't give you any more details than that, but it's quite the judge, whichever one of those two judges it was quite critical.
Will do.
Right. Nothing else?
No, thank you.
Nothing else? All right. Thank you both very much. You will be unsurprised to learn that we're not going to give an extempore judgment. Hot June days or otherwise, we don't think that it would be appropriate to give an extempore judgment in this case. We're very grateful to all of you for the excellence of the submissions, written and oral. We will produce our judgments as soon as we can. I'd like to think we have individually and definitely collectively a relatively quick reputation, but it comes at a time of the term when there are other things on the critical path. We can't promise when. I would hope that it was by the end of term, but as I say, we can't promise. You'll get a draft in the usual way. The draft is to correct typos and any other obvious factual errors. It's not to re-argue the cases, as you both know. I don't think there's anything else. So thank you both very much, and thank you for giving, in my Lord's phrase, us the morning off tomorrow.
Nice to see you, Carr.
Nice to see you. Different environment than last time.
As you say, different environment.
And we don't have to get up. We didn't have to start it at 7 either.
No. On the other hand, we didn't have to go to Singapore or Hong Kong or wherever it was.
I've got the next round of that particular dispute. In about 2 weeks' time. There's another one.
Yes, I don't think I've ever known the full details of exactly what's going on, but it did look to me as if it was something of a bean piece.
They're not great friends.
No.
Yeah.
See if John does.